Family Medical Leave Act. Hey, we've often heard about it, but how does it really work? Let's take a look at this case. It's a case that involves a real woman, Stephanie Hicks, and she was a police officer for the city of Tuscaloosa, Alabama. She became pregnant. She wanted to raise a family, and when she became pregnant, she said, I want to take a full 12 weeks of my family leave. Well, her superior wasn't pleased with that, and her immediate supervisor said, you know, I don't believe that she can take that full 12 weeks, and he was overheard saying, I think she should only get 6 weeks. Well, she took the full 12 weeks. She gave birth, came back, and she did not come back to a warm environment. Turns out that her supervisor was overheard again to say, you know, I'm going to get this gal, and he was using some very derogatory language, and she doesn't deserve to be here. She was reassigned. She previously had been working in a unit that did not have to work evenings or weekends. Now she was reassigned to a unit that required her to work evenings and weekends. Also required her to wear a flak jacket. She was concerned with wearing the flak jacket because she was breastfeeding, and she had come to believe and learn that wearing a tight-fitting garment like the flak jacket would create problems basically for her metabolism as she was trying to breastfeed. Therefore, she asked for an accommodation on that. They said, well, sweetheart, we can give you a bigger flak jacket. She looked at the larger flak jacket, tried it on, and said, well, this leaves big gaping holes, and that doesn't work the way a flak jacket is supposed to work because the bullets can come right through the big gaping holes. And they basically said, sweetheart, this is the way it is. You're going to be reassigned, and this is a flak jacket that you're going to have to use. Either take it or leave it. And she said, I'm leaving it, and I'm out of here. She quit. She then brought suit against the city, contending that she had been subjected essentially to a constructive firing. City said, no, 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 we didn't fire you. You chose to quit. More importantly, we made various accommodations. And finally, you know, if you really wanted to have a job after you quit, you could have gone out and found a job, but you didn't because you wanted to stay home with your newborn child, and that's what this is all about. On her behalf, it was argued, no, this was a constructive firing. You did not make reasonable accommodations. You were retaliatory when I came back by assigning me into a job that I now had to work nights and weekends, which I didn't have to do previously. In short, you were trying to make my life as tough as possible. And then when you didn't make the reasonable accommodations to take it or leave it, I couldn't have any choice but to leave it. Well, the case went to a jury, and the jury heard the evidence, weighed the evidence, and they came away finding in favor of Stephanie. And they said the city owed her, because of all the hassles that they created, owed her actually they initially found that she was owed roughly $75,000. Later the judge reduced that amount to $160,000. But anyway, came away and it was said she owed this, or the city owed her roughly $160,000. All right, case went up on appeal, went up to the 11th Circuit District Court of Appeals, and there the 11th Circuit Court of Appeals came away and agreed with Stephanie, agreed with her arguments based upon the record, and said the verdict is upheld and the city needs to pay her $160,000. Why? Because when she came back from her medical leave, they took retaliatory action. They changed her job, they made life more difficult for her, and in addition did not make reasonable accommodations for the medical condition that she found herself in as a mother who was attempting to breastfeed. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.